Since Joe Biden has taken office, his administration has gotten to work reversing some of the Trump administration's most controversial and destructive policies, including the elimination of the key environmental protections like the creation of new immigration restrictions and the sabotaging of the Affordable Care Act. That was what Trump tried to do, but obviously didn't. But obviously that didn't go through. After the Georgia runoffs, it's tempting to think that a Democratic Congress could just legislate these policies away, but the Senate filibuster is likely to remain intact for now, and effectively giving Republicans a veto over legislative efforts to undo everything that the squatter Donald Trump's regulatory legacy. Nor can President Biden ever reverse the damage just by signing a fat stack of executive orders, but instead, um, hold on. But instead, the law requires federal agencies to follow certain procedures, and many quite persnickety when they make changes to government policy, and reversing the Trump era policy will be the more difficult because that administration used its remaining days in office to create additional procedural obstacles to insinuate its decisions from reversal. The Biden administration will therefore have to balance a desire for speed against the need to protect its actions from court challenges. The threat of the judicial review looms especially large because Trump has stacked the courts with zealous conservatives who view the administrative state with suspicion and who are unlikely to take a charitable view of the new administration's actions. That will put a premium on good and creative lawyering. How can federal agencies move quickly while minding their P's and Q's? There isn't a single answer for that question right now, but instead, much of it will depend on the specific legal rules that apply to different types of policies. Some will be easy to reverse, and President Biden can rejoin the Paris Climate Accords without much fuss, which that already happened. He put those back in. Others will be harder, undoing the rollback of the habitat protections for threatened species under the Endangered Species Act, for example. That one may require a cumbersome notice and comment process. Nowhere will the trade-off between speed and procedural regularity be posed more starkly than in the context of Medicaid work requirements. Addressing them will be an early test of the Biden administration's nimbleness and competence. On the long list of the on the Trump administration's bad policies, allowing the states to impose work requirements on Medicaid recipients ranks high. Such requirements serve no good purpose, and data shows that they don't serve their goal of increasing employment. All they do is create the onerous paperwork and strip poor people, potentially 4 million of them, of their health insurance. Still, 19 Republican-controlled states asked the Trump administration to waive parts of the Medicaid statute to allow them to impose work requirements. The Trump administration has so far granted 8 such waivers, but for now, federal courts in Washington, D.C. have ruled that they're illegal. The court's reasoning is simple. By law, a Medicaid waiver has to advance the program's core objective, which is providing health coverage. Taking insurance away from people doesn't advance that objective. It's inimical to the court's opinions are strong and well reasoned. Last month, however, the Supreme Court had agreed to hear 2 cases about the validity of work requirements in Arkansas and New Hampshire. It's possible, even likely, as people have written elsewhere, that work requirements may get a sympathetic hearing from the conservative justices. But if so, the waivers could spring back into effect in the midst of a global pandemic. No less, a decision upholding work requirements would also set a dangerous precedent. Absent Supreme Court intervention, as Ian Millhiser noted, basically a future Republican administration would likely have to spend months or even years litigating the question of whether work requirements are permitted. But if the Supreme Court blesses the requirements, Republicans could quickly move to impose them the next time they win the White House, hopefully not anytime soon. So the race is on for the Biden administration to withdraw the waivers before the Supreme Court issue is decided, and probably it will be decided sometime in May or June. Easier said than done, right? But by regulation, the Secretary of the Department of Health and Human Services, Xavier Becerra, if he's confirmed, can withdraw waivers when he concludes that they no longer advance Medicaid's own purposes. But in doing so, however, the HHS has to abide by certain procedures it agreed to follow when it granted the waivers. Until 2 weeks ago, those procedures were modest. The agency would have had only to give objecting states a hearing to challenge the withdrawal before it took effect. In practice, that afforded the HHS lots of flexibility. Some hearings are elaborate, formal, and in person, but think here of a criminal proceeding. Others are brief, casual, and on paper. The process you might use, for example, is to challenge a parking ticket to eliminate work requirements. The agency could have held or expedited the stripped-down hearings once they give the states a chance to make their case, but that didn't bog the agency down in the procedural morass. If HHS if the HHS sprinted, it could have finished its hearings before the Supreme Court acted. But at that point, the work requirement cases would have been dismissed as moot, such as the court in a case last term, and it dismissed as moot. Basically, it was dismissed as moot because a challenge to a New York gun law that had since been repealed. But on January 4th, however, the Trump administration announced that it was changing the rules in a seemingly innocuous letter to what they call state Medicaid directors. The director of the Centers for the Medicare and Medicaid Services, Seema Verma, had offered additional details of the process for withdrawing waivers. One of those new details is that no withdrawal can take effect for at least 9 months. The change is a brazen, cynical attempt to protect work requirements long enough for the Supreme Court to rule on them. And while it's considered dastardly, it's also clever. When the states agree to the terms of Verma's letter, and the Republican-controlled states certainly will, if they haven't already, its terms arguably become enforceable as a kind of intergovernmental contract. I say arguably because the letter itself may be legally defective, as 2 Democratic congressional leaders have already argued in an angry missive to Verma. But the possibility that the courts might treat it as binding means that it will be risky for the Biden team to withdraw the waivers before the months are up. The Biden administration still has its options, however, and here's where the creative lawyering comes in. Among the states that have sought to impose work requirements, Michigan is really unusual. The state's governor, Gretchen Whitmer, is a Democrat who has been vocal about her distaste for work requirements. She has stuck with them only because under the prior Republican governor, the Republican-controlled legislator had passed a law requiring her to keep them in place, and from March to August 20th, somebody had served as a special counsel to Whitmer on her COVID-19 response. But Whitmer doesn't want to make it harder for Biden to undo work requirements, which is why Michigan won't be keen to sign Verma's letter. Without Michigan's signature, the old rules allowing for an expedited paper hearing would still apply in the state. And a quick hearing from Michigan would give the Biden administration leverage to put the Supreme Court case on hold while the other states' waivers are withdrawn. But here's how it might work. Shortly after Biden took office, his HHS could announce that it would be withdrawing all the work requirement waivers, but most of the withdrawals would take effect 9 months from now, per Verma's letter, but Michigan would take effect much sooner, basically say on May 1st. But moving on an expedited timeline, the agency would develop an exhaustive and carefully considered explanation for the withdrawals. To anticipate the red state objections, the explanation would make 2 things abundantly clear. First, the agency has reconsidered its legal position about the compatibility for work requirements with the Medicaid statute, and second, that the agency no longer intercepts or interprets the available evidence to suggest that such requirements can reasonably be expected to make people healthier. But once Michigan's waiver is withdrawn, the remaining waivers could be doomed. The Justice Department would then have a compelling reason to ask the Supreme Court to dismiss the pending cases involving Arkansas and New Hampshire, or at least if they delay ruling on them. There's no need for the court to resolve difficult, controversial cases that will become moot within months. The department could also argue, with real force, that the outgoing administration shouldn't be allowed to manipulate procedural rules in order to manufacture a basis for a court decision. But doing so would be especially anomalous, given that the work requirements are operationally complex and depend on extensive outreach to Medicaid beneficiaries. Even if the court approved work requirements in the early summer, neither Arkansas nor New Hampshire would have enough time to impose them before the withdrawal of their waivers became effective in the fall. But will this approach work? Maybe, maybe not. The Supreme Court could still plow ahead with the cases on the technical ground that the Arkansas and New Hampshire waivers would be valid for months more, and counting on the forbearance of the conservative supermajority might be dicey, but still the strategy is both straightforward and plausible. Now that the Democrats have taken control of the Senate, the House, and the Senate, um, the House, and the White House in itself. However, a second potential avenue for getting rid of work requirements may have opened in Congress, even if the filibuster remains intact. The Congressional Review Act is an obscure law that allows a bare majority of the legislature to repeal the Trump-era rules enacted with the administration's last 2 months so-called midnight rules. Matthew Lawrence, a law professor at Emory University, has argued that Congress might be able to characterize the work requirement waivers as rules and invoke the law to rescind them. Though Lawrence doesn't go that far, waivers that were adopted several years ago might even be subjected to the Congressional Review Act on the theory that they were never submitted to Congress for its consideration. In 2018, the Republican-controlled Congress exploited that loophole when it eliminated a 2013 automobile pricing guidance document from the Consumer Financial Protection Bureau. But using the act would have two key advantages. First, Congress's decision wouldn't be subjected to court review. Second, HHS would be prohibited from reusing waivers that are substantially the same as the Trump-era waivers, but the work requirements might be off the table forever. This legal strategy, though clever, is far from airtight. Using the Congressional Review Act might require Congress to get a positive legal opinion from the Government Accountability Office, which may not agree that waivers count as rules, and in any event, it is unlikely to move quickly. In addition, the act is a somewhat blunt tool. Simply canceling waivers that are bound up in broader state Medicaid programs may create more problems than it solves. A more surgical agency-led response would likely be preferable. But whatever the Biden administration chooses to do, the broader point is that even the simple act of rescinding waivers is hard. But remaking policy in other domains will be harder still, and that's why undoing what the Trump administration has done can't happen overnight. But it will take years of patient work, overseen by lawyers who may close attention to deal with the urgency that the times demand, and it won't be easy, but it'll be well worth it.